Strokes of fate can come upon us unexpectedly. What happens if there is no living will, or it cannot be found, and you're no longer able to consent to medical treatment due to incapacity? Who decides on medical treatment on your behalf? When will the Child and Adult Protection Authority intervene? If several people who are authorized to make decisions, for instance children, disagree. This is what this video is all about. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If you like this video, please share it. Your presumed will needs to be determined. Without an authorized representative, the law regulates who may consent to or refuse medical treatment if you're unable to do so yourself. This is when you're incapable of judgment. The following persons are empowered in descending order to consent if a person has lacking capacity to consent and to decide on your behalf. First, it's the person designated in a patient decree. If there is no patient decree, the welfare advocate with powers of representation in medical matters should decide. However, there may be no assistance. Then a spouse living in a common household or regularly and personally assists the patient shall decide. Or any person living with the patient in a common household and regularly and personally assists the patient. Otherwise, your offspring or your parents or your siblings shall decide on your behalf. This is so stated in the Swiss Civil Code. If relatives are unable or unwilling to make a decision, the Adult Protection Authority will intervene. A welfare advocate with the right of representation in medical matters will be appointed. A representative whom you don't know personally will determine your presumed wishes and make decisions on your behalf. Don't you want to avoid this? Even if your issue having different views, the Child and Protection Authority may have to intervene. Isn't it easier to decide for yourself and protect your relatives? Do your relatives know your preferences pertaining to medical treatment? Did you talk to your healthcare agent and your loved ones about quality of life and end-of-life matters? About dying with dignity and about your wishes, beliefs, fears, and hopes when faced with illness, aging, and death? Did you put your thoughts in writing? Especially after an accident or in the case of dementia, patients are often unable to consent to medical treatment. And in urgent cases, the attending physician performs such medical measures in accordance with the presumed volition and in the interest of the person lacking capacity to consent. It is helpful to record your wishes and ideas in writing in a living will. This serves as a decision-making aid. It will enable your medical representative to communicate and justify your wishes to the attending physician in the event of ambiguity or disagreement. Concrete and detailed formulations are not easy and often contradictory. Seek advice and make sure that your living will and or power of attorney can be found. Make a note of who should decide on your behalf about medical treatment. If you are no longer able to do so due to incapacity, what are your fundamental concerns? What is important to you? What are you afraid of pain or of loss of control? Do you wish to claim medical treatment without limitations? Are there any limits? Start preparing your living will and medical power of attorney. It will assure you and your family peace of mind later. Call me for assistance and do not miss any news or insights. Follow me on social media. Thank you.